Hi everyone, my name is Yuan Jiang, and this is my student ID. Now I will start my presentation. Hi officers, thank you for joining today's meeting. My name is Yuan Jiang. I have graduated as a financial officer. I currently work at KM, and I'm reasonable for handling BMW's case. I will provide some suggestions based on your questions. The 5 questions are mainly related to part. The first part is related to the BMW's financing method. The other part is related to the product quality liability. Let's begin with the first issue of whether the public could be interested in BMW share issue. As we know, the likelihood of the public taking up shares issue depends on some factors, such as the market condition, factors sensitive and company performance, and the time of the shares. Offering ordinary shares is the safety source for BMW. However, it's the highest risk for investor. The return on ordinary shares is not fixed. It's determined by the BMW's profit and the direct decision. The investor issues is paid after performance shares. If the BMW is liquidated, the ordinary shareholders must share in asset after the credit and the preference shareholders. In today's situation, BMW's earning is decreased and its share price decreased significantly. It will increase investor spending. They may consider that BMW's shares are too risky or lack growth potential. It will reduce investor confidence and deter the potential investor for taking up the share issues. Therefore, the public will unlikely to take up the BMW share issue in current market shares in the current financial market. On the other hand, issue the performance shares could be a better option for BMW. The performance shares is a fixed dividend. It's not affected by BMW's performance. The performance shares have no priority to receive dividend and claim when BMW liquidated. Therefore, the performance shares carry lower risk than ordinary shares. The performance shares is less risky and more attractive to investors based on current market situation. Moreover, it would be easier for BMW to ask high net worth clients rather than the public to invest in BMW. Because the high net worth clients have high risk acceptance and better investment capabilities. They have close relationship with the KM, the financial advisor, which help promote more trust and confidence in the investor advice. From another part, based on the regulator's standpoint, the Australian Corporation Act 2001 distinguishes between funds arising from high net worth clients and the public. According to the Section 706, BMW must issue a disclosure document when inviting the public to purchase the shares. Under Section 728, the disclosure documents cannot have any misleading. The high net worth clients of KM meet the requirements in Section 708. Therefore, it allows BMW exemption to provide the disclosure documents. It means it can benefit for BMW to decrease the cost and legal risk. Consequently, it's easy to require the high net worth clients to invest rather than the public. BMW should work together with the KM's financial planning department to provide the invest proposal to list something about the potential benefit and risk and accepted return. In addition, BMW should provide the comprehensive due diligence materials, financial projections, and a well-structured investment plan to determine that it is a good investment opportunities. Next, I will analyze the issue about the liability of BMW's quality. In this case, both company and BMW's senior management have liability. Firstly, we will analyze the company's liability. Under Section 119 and Section 124, the company is a separate legal entity. It can have the capacity to carry legal liability. BMW's product contain toxins. It means that the quality of product is not acceptable. Therefore, the company breached the Australian Consumer Law Section 54. The company is liable for the impact on customers and misplanting and fail to warn customers about the potential risk. In conclusion, BMW breached the Australian Consumer Law Section 18 and Section 33 and Section 29 subsection 1. BMW is liable for damage or loss suffered by the consumers. Regarding the liability of senior management, it's usually based on personal liabilities on the lack of knowledge or action related to the position. According to the Section 180, the senior management should take reasonable care about in the position. In this case, senior manager only realize the product have quality issues until customer complain. It means they lack reasonable care. They breach the Section 180 of the Australian Corporation Act. In addition, if in the future BMW found the senior management was aware of the product have quality issues and claim, and they know the claim is misleading, but they fail to take action, they would be held legally liable. In the case of cosmetics with acid, some financial director failed to meet the standard of care and diligence required by the Section 180. They have applied the inappropriate advice, failed to act in the best interest of the conscience. They don't have the risk management system. The court found that the director had breached the Section 180. The law said the director have responsibility to take reasonable care to avoid any foreseeable risk. Similarly, in BMWs, the senior management is involved in day-to-day management such as the improvement, development, production, marketing, and so on. As a key decision maker, they are expected to understand product's quality. They should establish a system to test and control the product and product quality. Management should do the quality testing before the production and sales. However, in BMW, the senior management only realized the product have the quality problems when the customer complained. It indicated that they lack reasonable care in testing process. Without reasonable testing, the risk is foreseeable. Consequently, the management failed to take reasonable care and breached Section 180. Above is my suggestion. Thank you for listening. If you have any questions, please let me know.